Otherwise,
I keep telling lawyers, the days have changed. Lawyers should realize this.
we realize it.
And also, it tells us what you think of the court, what you think of the Chief Justice.
The entire difficulties the litigants are
So at some stage, the judiciary will start asserting itself. At some stage.
I beg apology for
Beyond a time, we just can't take things lying down.
I beg apology for inconvenience.
You don't know the amount of hard work that goes. Judges work day and night in this court.
That is right.
Sitting committees, setting the whole system right, making the system work. Not in the High Court alone, but in the subordinate courts as well. And if you don't sense the change, then it's up to you. You have to be totally blind to not notice what changes have happened.
That's why we are got a good accommodation, my lord.
Despite all this, you see, despite all this, when this is the message given to the Chief Justice,
with all efforts of your lordship, we have got this.
You don't think twice when you boycott the courts. That's the problem. You allow a handful of people to dictate.
I beg apology for my lord, but
that I write in writing, sir.
I am giving with my memo.
You do that. I'll just adjourn this. Let's see how apologetic you are.
Next week,
At the request of Counsel the
after vacation, I will
list on 10th February.
Item number 2.
Item 2 and 3 going to be compromised, my lord. Arbitration matter.
All right.
That may be fixed, my lord.
All right. At the request of Counsel the petitioner, list on 6th January.
Item number 4.
May I please your lordship?
Yes.
The arbitration agreement, the parties to this petition are all partners of a partnership firm which is implemented as pro forma opposite party.
Okay.
Now let's turns to the partnership deed, which is at page 12. The relevant clauses at page 24. 14.
Yes.
In order to obviate all possible future disputes, differences between the parties hereto, and in event of any dispute arising out of this deed, touching and concerning these parties, the same shall be referred to arbitration, which shall be final and binding. The arbitration clause merits. Thereafter, my lords, the dispute arose when a letter was written by some of the partners to the bank to to freeze the bank account. And accordingly, my lords, this petitioner had to move an application under section 9. That is at page annexure 5. Page 6 had to move an application under section 9. That is at page annexure 5. Page 62. And this, my lords, has subsequently been allowed. Section 9 application has been allowed on contest. Now, while this matter was pending, the contesting partners also made applications under section 9 before the district judge. The same one has been partly allowed, the other was withdrawn. Now, since a dispute has arisen, and they have now, again, against those orders, they have all they have preferred appeals before the appellate tribunal. Now, hence, we gave a notice that your lordships will get. The reply is at 88.
Notice.
This is notice one. This is the notice under section 21, invoking the arbitration clause and seeking for appointment of arbitrator. At paragraph 8 at page 92, it suggested the name of two former judges of the Supreme Court,
This is arbitration petition 3 of 2022.
Yes.
Which petition are you arguing, sir?
I'm arguing 3. Yes, ma'am.
I don't know. We don't seem to have 92 pages at all. It's probably not numbered that.
Annexure 6, my lords, Annexure 6 series,
Right.
page 92, you have to get.
Let me just check. The numbering somehow is different.
Internal page 5.
Your lordship may see internal page 5 of Annexure 6.
Okay.
Paragraph 8.
The Annexure 6 is begins at page 52 for me. I don't know how. It's an email from Padma Lochan Mohanty to Rajiv
No,
Lochan.
no, my lord, so that
Later form and I think 20 odd pages later is there. The next is.
Oh, I see.
Which was issued by the lawyer.
my lord, the hard copy of the brief, I believe, is also available. Page 92.
Yes, page 92. Yes,
Paragraph 8, madam.
yes.
Thus an arbitrable dispute having arisen. My client hereby requests you to give your consent for settlement of disputes to arbitration under the provisions of the Arbitration Conciliation Act 96. We propose to appoint Justice Honorable Dr. Justice Arijit Prasad, former judge of the Honorable Supreme Court of India, Honorable Justice Sri Deepak Mishra, former Chief Justice of India, as the sole arbitrator to settle the aforementioned disputes. This is what we suggested. And then they respond at page 95. Your lordship takes page 96, page 2 of that letter. Para 1. We have been instructed to state that in the normal course, our client would have accepted the resolution of dispute through arbitration and acceptance of names suggested without any demur. But in view of the fact that your client caused the issue of notice for collateral purpose without appraising you of the true facts, etc., it goes on. Thereafter, my lords, 100 and at page 115, the other partner who is contesting, he suggests the name of Justice Chelameshwar.
No,
That's at page 115.
no, not the other part. I have objected. Only one partner's reply is placed.
Chelameshwar. So in the counter affidavit, stand is taken that this partnership deed has been superseded by a deed of assignment. And because since the deed of it does not contain the arbitration clause, this is no longer arbitrable.
You're party to the deed of assignment.
I am a party to the deed of assignment. One of them is not, but I am a party. The deed of assignment, my lords, is only readjustment of shares of the partnership firm. And so that your lordships in a minute, that your lordships will get. Page 19 of the counter, filed by opposite party number 2.
Yes,
Your lordships will find at column B at page 20. The shares as they stood in the partnership firm. Now, what has happened is clause 6 at page 22, your lordship is.
Yes.
Notwithstanding anything to the contrary content, either in the partnership deed or under obligations imposed under the Act or any other applicable law, in consideration for assignment of respective right, title, interest in the partnership firm by Padma, in terms of clause 2 above, the parties agree that Padma shall not be required to bear more than 50% of the prorated share in the total losses in the base of the profit sharing, that is 10.75 of the total losses arising on and from April 1st, 1990 in relation to the partnership firm. So what has happened is from 21.5% share that he held, 50% he has assigned in favor of me, the rest he retains, 10.75. So my lord, this is an arrangement which is contemplated under section 29 of the Partnership Act, if your lordships will kindly take that up. Section 29.
So there is no clause in this assignment deed which says the partnership deed is no longer.
No, nothing of that, sir. In fact, it gives a continuance to the partnership deed.
My lords, we see clause 9
Yes.
at page 22.
Yeah. Shall do all further acts, deeds and things.
My lords.
Hmm.
Execute all such documents, including a reconstituted deed of partnership.
All
So
right.
when my turn comes, I'll explain.
All right.
Now, your lordship will kindly see section 29 of the Partnership Act.
Yes.
Rights of transfer of a partner's interest. A transfer by a partner of his interest in the firm, either absolute or by mortgage or by creation by him of a charge of such interest, does not entitle the transferee during the continuance of the firm to interfere in the conduct of business or to require accounts or to inspect the books of firm, but entitles the transferee only to receive the share of profits of the transferee partners, and the transferee shall accept the accounts of profit agreed to by the partners. So, reading of this, what is clear, what emanates from this is the partnership as it stood will continue in its original shape. The new partners, even if they come in, they will not get a voting right or they will not be responsible for running the affairs of the partnership. It is only the share in the profits or the losses which will calculate down to them. So the partnership continues. What has happened by the deed of assignment is an arrangement which is contemplated under section 29 of the Partnership Act. There is no discontinuance of partnership. In fact, your lordship sees the entire document, deed of assignment. There is a reference to the partnership deed on each and every clause. And the partnership is still in and that is the reason all the parties have filed section 9 applications. They themselves acknowledge. And suddenly, after the hearing was concluded, one of them withdrew his application. So that is the only objection. We have suggested the name of two honorable judges. They have suggested the name of one. My prayer to your lordships, any retired judge of the Supreme Court, as your lordship may feel.
Yes.
So this is, my lords, basically a dispute between three brothers, not all the partners. So far as the three
So
brothers.
you are appearing for whom, Mr. Mishra?
Padma Lochan Mahanti, the OP number 2.
I'm appearing for OP number 1.
So,
After you finish.
all right.
So, my lords, there are 4 main objections that we have. One is the dispute has.
Your shares have come down by half, 50%.
Yes. So, now the issue here
Because
is.
this assignment deed was because of your giving up 50% to him.
No, others are also given.
This is basically, we have made a list of dates. I'll just quickly place that. If my lord would see that. A list of relevant
Yes,
dates
yes,
why this should not be entertained.
right,
On 2595, this partnership deed is executed by 6 children.
right,
The earlier partnership is reconstituted. Now the arbitration clause was shown to your lordship, that's clause 14 under the 1940 Act.
right.
Then on 13/2/2017, a family settlement was executed between some of the brothers, and the said family settlement does not contain an arbitration clause. This is my point number B of that list of dates. That family settlement has not been produced by them. Then 28/2018, the present petitioner, this is an important date, my lords. Rajiv Lochan Mahanti, while filing an objection to a section 9 application filed by his sister Sabita Mahanti in paragraph 38, has stated as follows. That I'll show from the record itself. The petitioner, being not a part of the partnership firm, post family settlement arrived at on 13/2/2017 between all brothers and sisters, cannot resort to arbitration clause contained in the partnership deed. So this is the present petitioner in section 11 saying so. In a section 9 application, it's all from records. I'll show that. Then my lord, 17/1/2020, the assignment deed, those relevant portions I have underlined and made
So
it.
this is right now a profit-making firm. What is it? What's the business for the firm?
The mine, they own a mine.
Mine.
operate The mine.
I see.
So it's a profit-making firm. Now, this is a dispute inter se between 3 brothers. Now,
No,
what
this
we are
is about the earnings from the mine, or what is the
it's
dispute
about earnings and also exclusion of one of the brothers from the entire scheme of things. So it's an interstate dispute between the family. It actually doesn't emanate out of a partnership. And the communication, my lord, in fact, I have Alpro of my lord's own judgment of the Delhi High Court. The communication inter se between parties, which should actually then make a section 11 maintainable, that communication in this case is incomplete.
No, there is no dissolution of the partnership.
No.
So the partnership deed is valid. That's what gives you the locus itself as partners, correct? Only the partnership deed.
No, provided the dispute inter se is relatable to that deed, because subsequent
It's
documents.
relatable to the firm. See, it's not so much to the deed
My lords.
as to the firm. This is about the earnings of the firm, and it's about sharing the profits of the firm. So the dispute relates to the business of the firm. It's not some private dispute outside of the business of the firm.
But my lords, these are all governed by subsequent documents where there is no arbitration clause.
No, those documents, which is what I asked him also, do those subsequent documents supersede the partnership deed? They don't. See, a partnership deed will come to an end when the partnership gets dissolved. It will be a deed of dissolution.
Okay.
That will substitute the deed of constitution of the firm.
Right.
Short of a deed of dissolution, the partnership deed continues.
So here there are 3 documents which have come after the partnership deed.
That's right. No, but do they supersede? The point is, do they supersede or bring to an end the partnership deed? They cannot possibly do that.
They, my lord, visualize a new reconstituted partnership deed.
No, not deed, partnership. See, there is a distinction between a
That clause, my lord, may kindly see.
Yes.
Which says that they must execute a new deed.
Correct. Which will show the reassigned shares.
My lords, may kindly see, that is at page 22 of my objection.
Right.
The party shall do all such further acts, deeds or things, and execute all such documents, including but not limited to a reconstituted deed of partnership,
Correct.
as may be required for giving effect to the agreements recorded herein.
Right.
Now, this document, it was, if my lords would see all along, this.
No, but till such partnership deed is actually drawn up,
My lords.
the existing partnership deed continues.
So here, what has happened, this deed of assignment is executed on the same day as the family settlement. Now, this assignment deed in several areas says, notwithstanding anything contained in the partnership deed, this will prevail.
That's right. So to the extent that it reassigns shares,
My lord.
this will prevail. But there are other clauses in the partnership deed which this assignment deed does not touch.
So what I'm trying to contend before my lord is that this is a dispute pertaining to this assignment and the family settlements,
Correct.
which don't have arbitration clauses.
Need not. Unless they rewrite, unless they say that the partnership deed no longer holds good, or it has been superseded, that they don't have to.
But this document virtually rewrites the partnership deed.
No, not virtually rewriting is the problem. It will rewrite to the extent of the shares being redefined.
So my first contention is that these three documents, they don't contain arbitration clauses, and hence this is not manageable. Then if my lord would see that list of dates, I was at serial number D containing that assignment deed.
Yes.
Then on 17/1/2020, the family settlement, that's a part of the record.
Right.
There again, the shares are carved out between several family members,
right?
But no arbitration clause in that. Then most importantly,
so all of you attempted mediation and failed, is it?
No, never been.
No. In fact, there have been 2 attempts at mediation, and one at Bombay and the other at Bhubaneswar, I believe. And both have failed at the last moment. One culminated in the deed of assignment where my learned friend's client resigned. He did not sign. The other did not yield any result. So conciliation has failed.
All right.
So far as my legal points are concerned, my lords, there are 2 more points. The notice invoking arbitration. Here I would rely on my lord's own judgment in Alpro, my lords. That doesn't specify any dispute. If my lords would see what was shown to the court, page 1918. So page number 88 of the petition, where notices are given to these 2 brothers by Kamal Lochan is the OP number 1 and Padma Lochan is OP number 2. Padma Lochan's reply has not been annexed to this section 11. Now, in this notice, if I may say so, next page 2 of that document, they describe the firm. Then page para 3, it is imperative to mention that Rajiv Lochan Mahanti, being the managing partner, has been continuing as such since 40 years. Then in view of clause 13, so-and-so Rajiv Lochan Mahanti continues to operate the bank accounts of the partnership firm being maintained so-and-so. And the notice C1 and 2 since past year have been interfering with the operations of the partnership firm, about which other partners have also raised their concerns. That on 30 October 2020, you notice C1 purported to with irrevocable power of attorney, which was issued in favor of Rajiv Lochan Mahanti from time to time to meet the requirement of the various departments of the government. That in view of this alleged notice prepared cancellation, then they mention about section 9. So this notice doesn't say that what is the dispute inter se amongst the partners.
No, I think the not being permitted to operate the bank account. Firm maintains its bank clause with the request to mark debit freeze in such accounts.
Only that much.
With a view to halting the usual operation of the partnership firm.
So now if we go into this, it is basically withdrawal of the power of attorney by one of the partners. And subsequently, so
no, and therefore bank accounts not being able to be operated.
So this is the part of the section 9 application. So before the honorable arbitrator, what their claims would be, what is the declaration that they seek, nothing is specified. They have simply then rushed to you have filed section 9. We have filed section 9, those proceedings are pending. And thus, in para 8, they say, thus an arbitrable dispute have arisen between the client.
No, if you go look at the top of page 92, my clients are entitled to and intend to make appropriate prayers for restraining you permanently from interfering with the operations of the firm and its bank accounts. So this is the dispute.
So that is their section 9 prayer.
Correct.
Which is there. So
that could definitely form one part of the claim that they'll have before the arbitrator.
So my second contention is that this doesn't specify what exactly is the dispute. And then our objection, which was given, we said that which is the underlying document that you want this dispute to be resolved, and kindly specify your disputes. That they have not, and no reply was given to us. So the communication for a section 11 to be maintainable, that communication is not yet complete. So these are our three grounds.
All right.
So in that note, I have given the judgment of my lords, and the Delhi High Court judgment also says that you have to specify the
Dispute.
dispute. Have also been recently relied by the Delhi High Court in 2022. I'll just begin with that 2022 judgment. Rahul Jain versus Jain. May I just place first paragraph?
Yes.
This is a petition under section 11 of the Arbitration and Conciliation Act, filed by the petitioners for appointment of an arbitrator to adjudicate disputes arising between the parties under a memorandum of family settlement, dated so and so. After this, the court may see para 26 at page 7. In the present case, learned counsel for the respondents have raised various objections as to the existence and validity of the arbitration clause, as well as with regard to the implementation of the purported settlement reflected in the memorandum of family settlement. They have submitted that the arbitration proceedings in the present case would be futile, as the disputes are within the category of deadwood. They have alleged that at least as far as Ashalata is concerned, and the substratum of the agreement in the form of various assets.
None of you has filed a suit, correct?
No, not yet.
In fact, some of you have gone for section 9.
No,
Malos, we have filed a writ application challenging this deed of assignment. In the sense, my lords, this is a lease with the government, my lords. You cannot, because
How can a deed of assignment be challenged in a writ
Yes,
petition?
my lords, I'm just explaining, my lords. My lords, here, my lords, the
You are from Mr. Kamal Lochan.
yes, my lords,
Ah.
opposite party number 1.
Right.
Let him finish, I'll explain.
All right, I'll explain, my lords, what the, if my lord would see what the present petitioner says in his section 9. That would be page annexure B/2 at page 24 of
Right.
my objection.
Right.
So here I would just show the cause title. Rajiv Lochan Mahanti is the OP number 1 in ARBP 52 of 2018. And this is filed by the OP number 1, and the relevant page would be page 38.
So he's resisting a.
He's resisting a section 9.
That's a.
Let me show that.
2018 application. That's
2018. In 2018, he says that the partnership deed cannot be relied upon. My lord may see page 38, para 38. That so far as the averments in so and so are concerned, it is respectfully submitted that no dispute as alleged has arisen between the petitioner and OP. Next line is, my lord, very important. The petitioner being not a party to the partnership firm, post family settlement arrived at on 13/2/2017 between all brothers
Actually,
and
this was
sisters.
completely mistaken in law. How can he not be part of the firm? He's still very much part of the firm.
No, in fact, here what they have done, Kamal Lochan is no longer, they have almost thrown him out.
Almost is different, sir. He's still a partner.
So this is his specific stand that you cannot resort to the arbitration clause contained in the partnership deed.
See, de facto de jure. That's what happens. I think amongst themselves, they say, okay, we don't talk to you or you are out.
So,
but legally, he still continues.
This, what I was trying to contend is that this is a dispute, probably an ego battle between the brothers, which probably shouldn't go to arbitration. They either if mediation is a institutionalized mediation can be a way forward. Otherwise, they should probably have to go to the.
See, it should not become a non-starter. So if three of you say, keeping aside all your past differences, you'll go with a clean slate and give it an honest shot, then I can refer. Otherwise, it's only postponing the inevitable.
Yes, sir.
You must be prepared to go in. And the two sisters will also be there. It can't be only amongst the three of you.
Oh,
So
there's
far as-
another brother. There's also another brother, 4 brothers.
Oh, I see.
4 brothers.
And so that's all the more reason that this is basically not a partner's dispute. It's dispute between two groups. me and Kamal Lochan being on one side and Rajiv Lochan, the elder brother, being on the other side. So dispute between two groups. And the other issue
to the firm. Dispute is with regard to the firm.
no, so far as others are concerned, they are all fallen in line. These two brothers are at loggerheads. Now, in view of his specific stand that the partnership from the arbitration clause has gone into oblivion, I don't think he can here turn around and say that this Section 11 is maintaining. And merely because we have filed Section 9, in fact,
This is a, I don't know, this is a stand taken at what stage, but clearly not correct in law. Because he doesn't cease to be a part of the firm.
so there the question would come probably that he himself having taken such a
Is there an
stand,
estoppel on this? No, there can't be an estoppel on this. It's a status, right? Partnership is being a partner of a firm. It's a status.
So, my lord,
That
these
can't
are all
change.
these are all in a way equitable reliefs. He cannot have different views at different
But
points.
he doesn't cease to be. See, legally he's continuing as a partner,
So-
whether he likes it or not.
So basically what we were trying to contend before your lordship is that his stand coupled with what has happened in that assignment deed and all the subsequent documents, they would indicate that they had visualized a new document which has not come into the picture. And the subsequent documents also don't have an arbitration.
All right.
So mediation, if they can take instruction, that is the other option. Is that
Am I audible?
Yes, yes.
So, my lords, here, this present brother, my lords, Kamal Lochan Mahanti is not a signatory to the, my lords, assignment deed.
Hmm.
He has challenged this assignment deed. Your lordship is aware that a partnership firm is nothing but a compendious method of describing the individual partners.
Hmm.
Now, the shares are all determined 21.5%, which has been recommended. Well, this partnership deed is cannot lie in isolation. This has been recommended by the state government for giving a mine. Thereafter, it has been approved by the central government. Now, my lords, without prior approval of the state government and the central government, the partnership deed cannot be altered because thereby you are giving more shares to a particular person, like 51% as my Mr.
No, the license for the mine is issued in the name of the firm.
My lords, even if it is in the name of the firm, I can show you, lordships, a number of decisions which says that the share structure cannot, it's of the apex code, share structure cannot
That's
be
a
altered.
separate cause of action. So when,
But that
Yeah.
is, my lords, I filed a writ application saying that the government is not taking any action. So this honorable court has remanded the matter back to the government, the matter in this light. That is insofar as the deed of assignment is concerned, my lords. Now, I'm not a signatory to that, but what has happened in this application, my lords, what he relies on this deed of assignment. That is what I am objecting to. I said this is honest in the eyes of law. So he is relying on that. Partnership deed, there is an arbitration clause. I also do not dispute that, my lords. So your lordship's suggestion of a mediation, my lords. And moreover, the second point that I'm raising is, my lords, as my friend has already said, that disputes are vague. The disputes should be clearly specified so that it can be referred to the arbitrator. And my lords, this family settlement, subsequent family settlement cannot be a part of the arbitration proceedings because here, my lords, there are other statutory implications, my lords. Plus, I am not a signatory to it. Now, if your lordships are suggesting for mediation, my lords, I'll take instructions from my client after holidays. Any day your lordship fixes.
No, mediation knowledge is, I have taken specific instructions that it's only, because here also the conduct has been such that they filed one of them filed a Section 9 application. Thereafter, before the orders could be delivered, he has withdrawn it and then gone ahead and filed an appeal.
We are not.
anyway.
My lord, I am appearing on behalf of one of the sisters, as your lordship has now found out, OP number 4.
Yes.
My lord, as my learned seniors have already said, my lord, these are a series of disputes which have happened. In fact, some of them are also being taken care of, being pursued before the NCLT. So, my lord, as my learned senior, Mr. Gautam Mukherjee said, my lord, probably mediation won't be anything fruitful because a lot of things have also happened under the aegis of NCLT, which did not yield a result.
Yeah, what is before the NCLT?
No, my lord,
As a company of the family, Another group.
As it is, this is the, my lord, as this is a partnership deed that your lordships are now looking after, my lord. There are also certain companies
I see.
where the brothers and the sisters were directors, my lord. That was
I see.
under the aegis of the NCLT. So
I
I
see.
only wanted to bring to your lordship notice that under the aegis of NCLT, for some of the disputes relating to the companies where the brothers and sisters were directors, my lord, numerous my lord, mediation took place. But unfortunately, my lord, nothing could yield result.
All
So my lord, I just wanted to bring to your notice that.
The litigation fatigue hasn't set in.
The holidays are setting in, my lord.
I only wanted to bring to your lordship the probably it might not be it might be a futile exercise. I only wanted to
All right.
Since
My lord, I'm just
I may be
praying for
pardoned,
your
my lord. I
lordship.
just have
If
one
he
more
doesn't
point.
agree to mediation, it's okay, my lord. We'll check up.
Let's-
But if your lordships are thinking of appointing an arbitrator, my lords, we'll take instructions from our client. Come back to you just after the holidays.
No, but again, I don't think you'll agree name. So it's better the court appoints.
Let's one small point. If my lords would see that family settlement of 2020, this basically what I was trying to contend, subject to what the court feels. This is basically a dispute pertaining to that family settlement. That is at Annexure 3, page 31. Which they have, it's a part of the Section 11 application. This basically changes the entire structure, and this has a forum where disputes have to be resolved. That if you could see, entire thing is restructured. No reference to the prior partnership deed, and my lord may see.
This is an old one.
This is the 2021.
Sorry, 2020. This is a new one.
Page 41. Ongoing legal proceedings. There's a clause where how ongoing legal proceedings have to be dealt with. Page 41. Clause 7.5, 7.6, and 7.7.
So this is generation coming in.
And my lord may kindly see next page. Future business, then avoidance of future disputes. There is a clause regarding avoidance of future disputes at page 42. Then governing law has been mentioned at page 44. Now, most importantly, at page 45, remedies. All remedies of A members, Group B members, or confirming parties in respect of families or under this memorandum, whether provided or conferred by statute, so and so. So this nowhere. So the 95 partnership deed has simply.
In fact, this actually seems to say that they are cumulative and not alternative. Just see the words used, and may be enforced successively
and concurrently.
So this actually does not.
But this doesn't have any arbitration clause.
No. This doesn't take away from all the other clauses of the partnership deed.
But there's no reference to the 95 deed at all. Why I'm relying on the stand of Mr. Rajiv Lochan Mahanti in that section 9 was the intent of the parties is to just get over the previous partnership.
Yes.
It's not that, that's the reason why it's not that it's some shoddily drafted petition. He took a specific stand in 2018 that in view of this family settlement, the partnership deed goes into oblivion, and that has further
legally, what does that mean? I don't understand.
That means, my lords,
going into oblivion is not a legally sustainable argument.
Correct. Now, what the parties intended, if my lord would see, because ultimately it is parties added him. 2017, he says that this clause is no longer applicable. Then in 2020,
in fact, the core of those 6 siblings being the partners, they have not inducted more partners, clearly. They continue this, only those 6 were partners, correct?
Yes. But this document brings in the next generation.
No, this document brings in means what? It doesn't bring them into the partnership deed. It probably,
So this
only says what their entitlements might be.
So what I'm trying to contend before the court is that the dispute now emanates out of this document.
I'm not sure because I think the arbitration clause is still in the partnership deed and that's what is being invoked.
And this has,
My lords, what Mr. Mishra is basically trying to say is, my lords, whenever it suits him, he relies on the partnership deed. Whenever it suits him, he relies on the assignment deed. That is what he
No, no,
was
I think-
hot and cold all over.
No, I think they all have to be read together.
Yes.
But for dispute resolution, you pick up the clause which is in there in the partnership deed because there doesn't seem to be a dispute resolution clause in any of the other
Any
deeds.
of the-
So it does not
Otherwise,
reflect the intention of the parties to do away with the dispute resolution clause in the partnership deed.
this nowhere says that this has to be read in addition to the partnership.
No, no,
deed.
that clause which you just read, it actually is the word cumulative and not alternative. And maybe enforced successively or concurrently. So which means everything exists.
And avoidance of future disputes, also it says that now the stand regarding mediation, my lord saw, but what they say at page
So that's the
42.
catch 22, right? This itself cannot be compelled. That's the whole problem. You see, the present petition is by one of 6 partners of a registered firm, which goes by the name of M.O.
MG Mahanti.
MG Mahanti. It is not in dispute that, among other things, there is a mining lease in favor of the firm, and one of the major areas of business of the firm is mining. Full stop. From the narration of the petition, it appears that disputes have arisen inter se, the partners of the firm, who all happen to be siblings. That is 4 brothers and 2 sisters. Paragraph. One of the brothers has filed the present petition under section 11 of the Arbitration Conciliation Act 1996, Bracket Act, seeking reference of the disputes that have inter se arisen between the partners to arbitration and for the appointment of a sole arbitrator in terms of a clause in a partnership deed dated 2nd May 1996.
95.
No, 95 is it? To which all of them, that is the petitioner and the opposite parties 1 to 5, are signatories. Full stop. That arbitration clause reads as under. Clause 14. It is plain that the reference to the Arbitration Act 1940 would include the reference to its subsequent words, which is the Act, which includes the Act, paragraph. In resisting the plea for the appointment of an arbitrator, the submission made on behalf of opposite parties, particularly opposite party number 1, Shri Kamal Lochan Mahanti, and opposite party number 2, Shri Padma Lochan Mahanti, is that there have been subsequent deeds of family settlement, assignment, which have virtually rewritten.
My lords, because my lords, my stand is not that. My stand is, I was never a signatory. It is honest in the eyes of me. Your lordships will note my stand, because then I will, otherwise, I'm not saying, because he has never disclosed this family settlement to me. He does it only in the arbitration.
All right. You see, in resisting the appointment of an arbitrator, the stand of Mr. Padma Lochan Mahanti, opposite party number 2. No, first I'll deal with this, is that the members of the family have subsequently executed an assigned deed dated 17 January 2020, and also a memorandum recording family settlement on the same date, both of which documents have rendered the original partnership deed inoperative or non-est. Full stop. The stand is that these subsequent documents do not contain an arbitration clause, and therefore there is no basis on which the petitioner can seek reference to the disputes to arbitration. Full stop. The second objection is that the notice under section 21 of the Act issued by the petitioner to the other partners, to the other siblings, does not clearly specify what the dispute is about. Full stop. Thirdly, it is contended that the petitioner himself, in resisting an application filed by one of the siblings, that is, Miss Sabita Mohanty, right?
Yes. Sabita.
Under section 9 of the Act, disputed being part of the partnership firm, and questioned the maintainability of the petition under section 9 of the Act itself. Full stop. The contention is that now the petitioner should not be allowed to reprobate and ask for the appointment of an arbitrator. Paragraph. As far as Mr. Kamal Lochan Mohanty, opposite party number 1, is concerned,
They have taken the.
he has questioned the very assignment deed itself, to which he is not a party.
Which.
Full stop. According to him, the said assignment deed dated 17 January 2022 is of doubtful legal validity, and he has questioned it in separate legal proceedings.
And I've also taken the stand that
Yeah.
he cannot reprobate.
Right. Mr. Kamal Lochan Mohanty also contends that the petitioner, having virtually given up on the partnership deed, cannot go back to rely on it for the purposes of appointment of an arbitrator. Paragraph. The other opposite parties, more or less, are none of the others has filed any counter, right?
No.
No, my lord, we have not filed any counter, my lord. And for opposite
Right.
party number 4, we have not filed, my lord, because our stand is, my lord, after the family settlement, we have nothing to do with the partnership. But
The stand of opposite party number 4 is that after the execution of the memorandum of family settlement, no purpose would be served in resorting to the partnership deed, clause in the partnership deed for having the dispute settled. Full stop.
my lord, may I only clarify? My lord, what I was saying is, my lord, we were the partners, but after the family deed, we have already given up our partnership in the partnership deed. So that's between whoever after the family settlement.
Okay, saying that having been a signatory to the memorandum of the family settlement, the opposite party number 4 does not want to be part of any dispute, which is essentially between the other partners to the partnership firm. Paragraph. The above submissions have been considered. So at the outset, it requires to be noticed that the said partnership firm continues as such till date, and the legal basis of the firm is itself the partnership deed, which till date has not been superseded by any other document. Full stop. Particularly, neither the deed of assignment dated 17 January 2020 nor the memorandum of family settlement of the same date contains any clause that actually supersedes the partnership deed dated 2nd May 1995. Full stop. Paragraph. Mr. Gautam Mishra, representing Mr. Padma Lochan Mohanty, drew the attention of the court to clause 9 of the deed of assignment, which reads as under. Full stop. While the above clause does contemplate a reconstituted deed of partnership, it is not in dispute that there has been no such reconstituted deed of partnership drawn up yet. Full stop. In other words, till date, the original deed of partnership continues as such. Stop. Even clause 9 of the deed of assignment does not override the partnership deed, and in particular the arbitration clause contained therein. Paragraph. Turning now to the memorandum of family settlement. The court's attention was drawn to a clause which is clause 17, which is titled Single Courts Remedies, and which reads as under, take from page 45. It's computer page 61. Again, the above clause does not supersede the either the partnership deed or the arbitration clause thereunder. First of all, on the other hand, it appears to reflect the intention of the parties that all the other documents involving the parties would be single quotes cumulative, unquote. And all the remedies contained under the other documents between the parties would be single quotes cumulative and not alternative, unquote, and can be enforced single quotes successively or concurrently, full stop, unquote. In other words, the intention appears to be that all the documents which continue to exist can be enforced, notwithstanding the memorandum of family settlement. Paragraph. Consequently, the court is not able to agree with the contention of the paragraph. As far as the challenge to the validity of the deed of assignment is concerned, it's subject matter of separate proceedings. The court is not required at this stage to express any opinion thereon. Full stop. As far as the present proceedings are concerned, the court is only to examine whether there is a valid agreement containing an arbitration clause and whether there are disputes that have arisen between the parties which require to be referred to arbitration. Full stop. A perusal of the paragraph, a perusal of the notice seeking the appointment for an arbitrator does indicate what the nature of the dispute between the parties is. Full stop. Nevertheless, the court would like to observe that it will always be open to the claimant parties to specify in greater detail what their claims in the arbitration are likely to be, and for the other parties to indicate either in the response thereto or in their counterclaims what according to them the disputes are. Full stop. This, in the considered view of the court, does not come in the way of the appointment of an arbitrator as such. The reference was placed on the decision of the Delhi High Court, decisions of the Delhi High Court in Alupro Building Systems Private Limited versus Ozone Overseas Limited, 2017 162 DRJ 412, and Rahul Jain versus Atul Jain, 2022 SEC Online DEL 3860, to urge that the petitioner has not made out a case for reference to the dispute to arbitration in terms of the clause in the partnership deed. Paragraph finds that those decisions turned on their own facts, and in one of them, bracket Rahul Jain versus Atul Jain, bracket, there were other proceedings pending in the civil court. Full stop. As far as the present partnership is concerned, there appears to be, apart from the section 9 proceedings under section 9 of the Act, no other proceedings pending in any civil court. Full stop. Paragraph. While it is true that petitioner may have, in response to the petition filed by opposite party number 4 under section 9 of the Act, contended that he is no longer part of the partnership firm.
And also one.
All right. Response to the petitions filed by opposite parties 1 and 4 under section 9 of the Act, that he is no longer part of the partnership firm. The legal position as of date is that the firm does exist and exists on the basis of the partnership deed, which contains a clause and which partnership deed has not been superseded. Full stop. Therefore, all the parties to the present petition continue as partners even till date. Full stop. Paragraph. For all of the aforementioned reasons, the court rejects the objections of the opposite parties to the plea of the present petitioner for the appointment of an arbitrator in terms of the arbitration clause in the partnership deed dated 2nd May 1995. It is clarified that all the contentions of the parties on the merits of their disputes are left open to be decided by the arbitrator in accordance with law. Paragraph. Although there have been names suggested on both sides of who should be the sole arbitrator, parties are left it to the court to appoint a sole arbitrator. So would you want, why don't you go for a lawyer if you're so inclined? Or should it only be a Supreme Court judge, retired judge of Supreme
In a lighter vein, since there's no amount fixed, so we don't know how much the fees and all would. So that's also.
We don't have any objection provided the statute also that.
So I'm just suggesting Mr. Kara, Mr. Rudra Prasad Kara, Mr. R.P. Kara.
Maybe take instructions from the client.
No, again, instructions is going because they're not going to agree on any name.
No. Just after vacation, who, if.
No, let's do it today. Let it be done today.
Hello?
My lord, let be a retired judge of the
Supreme Court, is it? All right.
So, but then we all can't go to Delhi. So,
so that's the other issue. Correct.
Family is quite well known in Orissa, so it would be better that. Yeah, it can be.
Your choices are very few, so it's.
Well, in fact, in another case where your lordships were pleased to appoint Honorable Justice Lokur, Justice Lokur, my lord, we have been doing all online. I mean, except for when parties are insisting that Justice Lokur is
no,
asking.
we leave it to the court. Because,
so if you can't transmit online, then there's nothing like that.
Otherwise, they'll get somebody from Delhi.
Justice Vinit Saran? You have online proceedings that even he can conduct.
Since he was here, there might be renovation of the parties.
Oh, I see.
That is what.
But then all retired judges of the Supreme Court from here.
No, no.
Oh, you will say any retired judge?
Any retired judge. Any retired. It could anybody in your lordship's opinion.
Then Justice Nageshwar Rao?
Nageshwar Rao.
All right. With the court appoints Justice L. Nageshwar Rao, former judge of the Supreme Court of India, as sole arbitrator to adjudicate the dispute between the parties, including their claims and counterclaims. The learned arbitrator will fix his terms.
Right away. I was suggesting Mr. Nariman's name to my client. He said we will be back. We're not too happy.
Thank you.
Wishing your lordships a very happy Christmas. And
wish all of you a happy New Year. Right.
You're all great.
Thank you.
Item number 5.
My lord, item 5, I am sorry, my lord, last occasion, my lord is given a last chance to file the counter. Because
Yes.
but wrongly, this letter has gone to East Coast Railway instead of Southeastern Railway. So can
Madik is always determined to disappoint me.
I can't give more pen to my friends.
All right. Mr. Padi assures the court that the reply will probably be filed on or before 30th January 2022. List on 3rd February. All right.
3rd January.
3rd February, sir.
Wishing your lordship also a happy Christmas.
Thank you. Thank you.
Item number 6.
Item 6, today I am appearing for the sole opposite party. After 2 weeks time to file the counter appeal.
All right. Reply be filed within 4 weeks, rejoined for the next date, 10th February.
Item number 7.
Lordship, I'm appearing on behalf of the petitioner, my lordship.
Yes, please.
My lordship, this is an application for appointment of an arbitrator.
No, what happened? Notice was served or not?
Yes, yes, my lordship, notice was served. We
For
filed
valid
the-
service, correct. And Mr. Ashok Manti had had filed Vakalatnama on behalf of opposite party number 3. Where is he? We'll just pass it over once. Huh?
Okay.
Okay, maybe his name is not reflected. You say the name of Mr. Ashok A.K. Mahanti be reflected in the cost list. List on. We'll have in the opening week, 6th January.
Yes, my
All
lordship.
right. Specialist. All right.
Specialist trace admission item number 1, CRLMC 2425 of 2016.
May you please, Your Lordship, on behalf of Mr. Picasso, this case may be permitted to withdraw.
All right. Dismiss is withdrawn. All right.
So placed.
Specialist item number 2,
None appears dismissed.
specialist item number 3,
Same order.
specialist item number 4,
The matter is infructuous, Your Lordship.
Dismissed as infractions.
item number 5,
None appears dismissed.
item number 6,
Same order.
item number 7,
Same order.
item number 8,
Same order.
item number 9,
Same order.
specialist item number 10,
None appears dismissed.
item number 11,
None appears dismissed.
item number 12,
Item number permitted to withdraw, Your Lordship.
Okay, dismiss is withdrawn. All right.
item number 13,
None appears dismissed.
item number 14,
None appears dismissed.
item 15,
None appears dismissed.
item number 16,
None appears dismissed.
item number 17,
None appears dismissed.
item number 18,
Item number 18, Your Lordship, permitted to withdraw, will raise all the point at the time of hearing.
All right, permitting the petition. All right.
Lordship, liberty will be granted to at the time of hearing charge will raise.
That's it. Permitting the petitioner to raise all pleas at the appropriate stage. Petition is disclosed. All right.
item number 19,
Please, Lordship, with no instructions, liberty may be granted to file afresh if the.
Not necessary, sir. No instructions dismissed.
Obliged, Lordship.
item number 20,
The matter is infructuous, Your Lordship.
All right, dismisses and structures.
item 21,
None appears dismissed.
item 22,
My lord, no instruction, my lord.
No instructions dismissed.
item number 20,
Your Lordship, item 23 to 26, all are infructuous.
Infructuous 23 to 26.
item number 27,
None appears dismissed.
item number 28,
Lord, permitted to raise all the points.
All right, permitting the petitioner to raise all pleas at the appropriate stage. All right.
specialist item 29,
None appears dismissed.
item number 30,
My lord, item 30, permitted to raise all the points of the appropriate.
All right, permitting the petitioner to raise all pleas at the appropriate
Obliged.
stage. All right.
item 31,
None appears dismissed.
item number 32,
None appears dismissed.
May I please, Your Lordship. The challenge.
32.
Yes, my lord.
Ah.
Challenging initiation of the criminal proceeding, my lord.
Hmm.
In this case, my lord, the SI of the Intelligence Bureau lodged an FIR before the police that 3 foreigners are staying in the hotel of the petitioner. The petitioner number 1 is the managing director. Number 2 is the employer. My lord, it is alleged that after staying, they did not inform the police, the IB within 24 hours. The fact remains, my lord, They have only sent one name of the one persons. Other two persons could not send because of their network problem. Thereafter, they have immediately informed to the police. What is these three persons are staying in a hotel. Like I have intimated Annexure 2. They have received, and that is a jungle area. That network problem was that one person has sent. They have admitted. Name of one person has been sent. It is mentioned. You will also kindly see the FIR. On verification of FIR, page 12.
So this is a Foreigners Act violation.
Yes. They have not violated.
That's all right. So that will be decided. The matter goes for trial.
Will also kindly see of 16:6. Will also kindly see.
No, but unless the matter goes to trial, how does one adjudicate this?
But the matter cannot be made out, my lord, because my lord, it is 8 says, my lord, the form still shall be available online. At that matter, that form is not available due to network problem. For which you could have sent within 24 hours. That is the problem. At that time, in the year 1997,
three Chinese nationals, and this is the intelligence bureau. So
yes.
The evidence will have to be got it.
No,
permit you to raise all pleas at the appropriate stage. So permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
Because I want to take issues whether the police has closed the case.
That's okay. If it is closed, it's even better than for you. That's all. You say the interim order is vacated. A copy of this order be sent to the concerned trial court. Right.
Item number 33.
No instruction.
No instructions dismissed.
Item 34.
Order wherever it is vacated.
Item 34, my lord, liberty may be.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item 35.
Dismiss is withdrawn.
Liberty may be given.
No liberty, sir. This is a 2017 case. All right. Dismiss is withdrawn.
Item 36.
36 infructuous.
Infructuous dismissed. All right.
Item number 37.
Permitted to raise all the questions at the appropriate stage.
Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 38.
38 and 39, my lord, both are for passing. The short fact is that the petitioner, while working as branch manager, disbursed certain house building loan to the RSP employee. On the allegation is that the loan could not be recovered because of the collateral weak collateral security, my lord. It's a fact remains. I will raise. Now the loan has been liquidated.
All right. So permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
My lord, I will file an application. That may be considered. Now it is the stage of charge.
This will cover all that, sir.
My lord.
Along
with the documents, my lord.
Right. The interim order is vacated. All right.
38 and 39.
Both.
39
put them together. Right.
Specialist for orders, item 40.
There's no indication one word only discharge application.
Doesn't matter, sir. All pleas you can raise means you can file an application, you can do everything. Right.
Item 40, no instruction, madam.
All right. No instructions dismissed.
Item 41.
None appears dismissed.
Item number 42.
None appears dismissed.
Item number 43.
None appears dismissed.
Item number 44.
None appears dismissed.
Item 45.
Memo taken on record dismisses withdrawn. Right. In terms thereof.
Item 46.
None appears dismissed.
Item number 47.
57, your lordship, on behalf of J.K. Mahapatra, this matter may kindly be taken up along with another matter, CRL number 2148 by 2021.
21. What does that to do with this?
Lordship, on behalf of J.K. Mahapatra, lordship, may kindly taken up after vacation.
Permit you to raise all pleas at the appropriate stage, madam. That's better.
Your Lordship.
This is.
Father-in-law, all right. Is it permitting the petitioner to raise all pleas at the appropriate stage in the trial court? The petition is disposed of. There is no interim order, so that's all right. Right.
Item number 48.
May I pray for an adjournment, my lord?
No, why? You're there very much.
One adjournment only.
No, tell us why. Permit you to raise all pleas, sir. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
Item 49.
None appears dismissed.
Item number 50.
None appears dismissed.
Item number 51.
None appears dismissed.
52.
Same order.
No.
Item 53.
May I please, your lordship? If the petitioner really transferred that file, not if your lordship permit me, I can raise the two questions. Lord, in fact, the petitioner is taken away the file and want to engage somebody, but since the name has not been listed, I was appearing. The simple fact I am producing, I don't mind if I understand really love the petitioner. The simple fact is that the Tahsildar Keonjhar has filed the FIR against the petitioner, my lord. The reason is by showing some disputed document, I have obtained the ROR. The question is now, the moot question is, my lord, who has issued the ROR? The Tahsildar himself issued the ROR. Was there any legal bar to scrutinize the documents? No, there are no scrutiny. So in this case, if any allegation is there, or any mistake is there, that can be raised before the civil court, and that can be quashed, my lord. Now, if I say, my lord,
468, 471 can't go to civil court.
then I think the main culprit is the Tahsildar himself who issued the order, my lord.
You summon him, sir. Summon him as a witness.
So that is why I pray, Lord, that he should be quashed, my lord, because issuing party is him.
All right.
And I have issued it.
All right. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated. All right.
Item number 54.
None appears dismissed.
Item 55.
Dismissed is withdrawn. All right.
Item number 56.
None appears dismissed.
57.
None appears dismissed.
58.
We have no instruction in the matter.
No
Your
instructions dismissed.
On behalf of Mr. Mahapatra, withdrawn.
Dismiss. The memo is taken on record. Dismiss is withdrawn. All right.
All right.
Item 61.
61 name release. This is the application process that the present petitioner illegally arbitrated order dated 1/7/17 passed by the law and sessions of Khurda Mallership. In this case, Mallership, the law and court bill has rejected the application of 2055 CRPC Mallership filed by the petitioner Mallership.
Without you appear on Monday, then
the present petitioner has already in dual Mallership.
Nothing say infractuous. No interim order. Nothing here. It's already infractuous now. NBW issued to you. The present petition was filed against an order dated 1st July 2017, passed by the Sessions Judge Khurda in criminal miss bracket PMLA case number 34 of 2016, rejecting the application for exemption from appearance under section 205 CRPC. Full stop. There has been no interim order in this proceedings thus far. Obviously, the petition is rendered infractuous and is disposed of as such. Right.
Item number 62.
None appears dismissed.
63.
No instruction.
No instructions dismissed.
Item number 64.
None appears dismissed.
Item 65.
Mr. Dada, completely different thing. One thing they've not succeeded in this court is about the gown. You have the bar council. It's an anomaly because we spend so much time designating senior advocates and then everybody is wearing that gown. Something has to be done.
Ireland has also earlier.
I know it's not stopping. Even the gentleman who just now appeared is wearing a gown. So
Not senior, exactly not senior.
No, from a judge's point of view, we don't keep looking at whether this long sleeve is there or not. The flap is there and, it's misleading even for the client. That's what. See, earlier I was told that many of them had already got this count, so it will take some time to, phase it out, but that's not happening.
Exactly, it is not senior count, but some counts are designed in that way, like my other friends count.
Yeah, it's perfect. In fact, everybody on the government side also wears the correct gown. I think somewhere you'll have to make an extra effort. All right.
Right here, I have challenged the order taking cognizance under Annexure 7.
Yes.
It's out and out a political dispute, and the election case was also filed, which has been taken to be infructuous. A petition number MLA of the ruling party. During that period also, he was the transport minister. What has actually happened, my lord? Some allegations have been made in the election petition, but when the election, my lord, might see page 34, election petition number 11 of 2014 against opposite party, my lord, Subrat Tarai. My lord, here what has actually happened with this case continued as it is, and it has been disposed of, I mean, it is tended to be infructuous. During pendency of that election case, another lady, was set up to who lost an information. That investigation was carried on, a thorough investigation was done, and it was ended in final report. That nothing has been done, but so no sorts of any allegations which have been made that has not been proved. Challenging the final report, a protest petition was filed, which was registered as 1CC case number 196 of 2015. Till then, notice has been
but
issued.
this is assault with use of criminal force, 354B.
354B. Let me see that allegation. Though it's not made out.
No, but
they said during election campaign. The election campaign, some ladies opposed. Why you are doing this, that? It has been settled because election is over. That Raj is over, and I am also sitting MLA now. It has been this was a compromise settlement. My lord may take off in my lord's next sitting. It would have been compromised by that because both sides have forgotten this dispute.
The law does not forget. That's the whole problem.
In between 8 years have been passed. They have because party they have changed the party.
At the request of Mr. Lana, senior counsel for the petitioner, a list before the roster bench on 20th February. Interim order.
Item number 66. 66.
There is no interim order. There is no interim order. There was no interim. All right, 20th. Sorry, 66. None appears dismissed.
Item 67.
Lordship 67 and 68 permitted to withdraw.
Okay, dismiss is withdrawn.
Item number 69.
69, no instructions.
No instructions.
Permit to withdraw.
All right.
Item number 70.
None appears dismissed.
Item number 71.
None appears dismissed.
72.
72, Lordship, may please, Lordship. Here, Lordship, in fact, last occasion, because of my absence, the case is dismissed for non-prosecution, and I filed a CL application for restoration, Lordship.
What's the main matter?
Yes, Lordship, I'm placing, Lordship. Here, Lordship, the petitioner, one of the co-accused persons in a case of 302 and 201 of IPC, Lordship.
Yes.
Lordship. One of the co-accused persons in the charge sheet, he has referred his Lordship with the Honour Court that asking for a passing of the criminal proceeding on the ground that those persons, those who have faced the trial, they have been acquitted on the ground that there is no material available in the against, and the London trial court has been pleased to say that except suspicion there is no case. Subsequently to this ex-Lordship, the basis of implication of this petition is that the informant, the wife of the deceased, she has said in an FIR that because her husband was shopping under this person, and some of the henchmen of this person had invited that deceased to the shop, accordingly somehow he was killed. But in the trial, none of the person concerned, no witness have said anything, and they turned hostile, Lordship. Now the basis of implication so this case is petition is concerned, Lordship, that is the statement of the informant who turned hostile, along with other witnesses. None have said anything about the occurrence, Lordship. None have said how the death was caused, and everything is there, Lordship. Except the IO and the doctor, none have supported the prosecution case, Lordship. And that is what the final I have filed.
Cite the judgment.
That is always available, but my entire endeavor is that in the event this person will be allowed or compelled to face the trial, Ultimately, it will be abuse of process.
No, no,
That is the point.
no.
Other method can be developed. Lordship. That
No
is
grounds made out for restoration. The application is dismissed. Sorry. Sir.
here. Lordship, one more thing may I say. Lordship, kindly see the interim order pass in this case. That says that the enroll issued against me after taking cognizance by the land trial court, land STGM, that was somehow this honorable court and pleased to not to take any coercive steps. In that event, if Lordship is not inclined to allow this application, I may pay that on my surrender, I may be allowed to go on bail and I will be facing the trial. Lordship.
No, no, no. We can't decide the bail here, sir. That the court will decide.
On my surrender, Lordship. I will surrender and land trial court may consider that.
That will not pass. Sorry. Yes.
Then let's say that I may raise all the points at the payment.
No, no, that is already there, sir. You will always raise all the points. Yes.
Item 73.
May it please, Your Lordships.
Yes, please.
Your Lords, the cognizance order under Annexure 4, page 30, it is under challenge.
Yes.
Lords, the entire dispute has arisen out of a breach of contract and that the informant had filed, my Lords, one complaint case that Your Lordship may find at page 24.
Yes.
The entire allegations in the complaint case is merely of a breach of contract and is of a civil in nature. If Your Lordship peruses
there is no compromise between the two of you, sir. The claimant come forward to say that he is not pressing the complaint. So,
my Lords, there has been no compromise, my Lords.
So that's difficult for this court then to quash.
My Lords, my only
can't go into the merits.
My Lords, my only submission is the entire. If Your Lordship peruses the complaint,
establish it in the trial court then, sir.
As Your Lordship,
permitting the petitioner to raise all pleas at the appropriate stage. Right.
Obliged.
All right.
Item 74.
None appears dismissed.
Item number 75.
None appears dismissed.
76.
Same order.
Item 77.
Same order.
Item number 78.
Same order.
Item 79.
Same order.
Item number 80.
May I please,
And the petitioners is the villager of a bonus, my lord. They pay for questioning of the GR case pending before the London JMFC people, my lord. Matter has been already settled, my lord. I have some photograph.
Photos won't do.
My lord, already the school is established.
What?
And is also established. Villager established, constructed the house of the OP number 2. My lord.
All right.
Matter already compromised.
Then you pointed out to the trial court, permitting the petitioner to raise all pleas at the appropriate stage in the trial court.
But 3 SAC Act is there. 3 SAC Act is there. 506 and 3 SAC.
That's what. You go to the trial court and file.
My lord.
All right.
Item number 81.
My lord.
Obliged.
And as 3 is the cognizance order. Your Lordship, the ingredients of section 130 NI has not been satisfied in this case, my lord. Your Lordship, kindly see the complaint petition order annexure 1 at page 9, wherein the check is deposited on 7/3/2012 and the same is returned back on 10th March 2012 and the demand notice has been sent on 11th April 2012. So there is a delay of 2 days.
So all this the trial court will examine. Whether it's 2 days.
Repeat case for question.
Let the trial court examine that. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right.
Item number 82.
None appears dismissed.
83.
I am for the opposite party in this case, man.
I am for petitioner, my lord.
My lord, I will be permitted on behalf of Subhashish Patnaik in this case.
My lord, this case happened, my lord. My re-examination was rejected. Opposite party reconsideration was allowed. This is second time allowed. You will not kindly see annexure 4, page 24. Last portion.
Annexure 4.
Yes, ma'am. Last portion.
So far as
the petition 1917 of the accused is concerned, it is found the petitioner could not be further questioned 1718 on the ground of illness and contracting law. As mentioned, the foregoing paragraph of similar also filed accused on 18/5/2007, and the same was allowed by the court subject to payment of witness. And then
Page 34, my lord, upper portion, main paragraph. The complainant was present, but Lord and Council of the accused did not turn up for further consideration of PW. According to the PW was discharged. This is second time. My lord, the Supreme Court decision is the filling of lacuna due to oversight. My pleading is in page 8, annexure 1.
You are the complainant.
Yes, I am the complainant.
See, at your instance now for 5 years, the trial has not moved.
Yes, my
How
lord.
that
That stayed here, you might.
So at your instance, your own complaint has got stayed. To help you, sir. By now the trial,
My re-examination is rejected. My lord, I am citing the judgment of the my lord. Kindly be here.
All right.
My lord, after the evidence was closed, thereafter he has filed this section 311 petition recalling the evidence of.
Lacuna in prosecution.
Worked out. No, my lord, the impugned order, my lord.
It is stayed, my lord.
So at your instance, your complaint case has got stayed, sir.
For 5 years, the case is not being able to be proceeded with.
I am pressing the 99 Supreme Court decision, 17 OCR Supreme Court decision. Lacuna in prosecution case is not to be equated with the fallout of the oversight committed during trial either. Producing relevant error. No party in a trial can be foreclosed for correcting error. If proper evidence was not adduced due to inadvertence, the court should be magnanimous in permitting such mistake. Your lordship might kindly see the paragraph 7 of my lord K.T. Thomas judgment. It is common experience in criminal court that defense counsel would raise objection whenever courts exercise power under section 311 of the code of under 165 Evidence Act, saying that the court could not fill lacuna in the prosecution. A lacuna in prosecution is not to be equated with fallout of an oversight committed by public prosecutor during the trial, either producing irrelevant.
How is this relevant, sir? This is the accused asking for re-examination of PW1.
Re-examination is allowed. My re-examination was rejected. I am a special part of my father. I could not inadvertently oversight. I could not mark it as exhibit. It is all my pillar of the case will fall out. My if re-examination allowed.
My lord, if your lordship permits me, my lord.
And the paragraph 8, lacuna in prosecution case must be understood as inherent weakness of the latent ways in the material prosecution.
So only agreed by your not being permitted to adduce recall.
Also, I part the document.
Yes, now what do you say?
My lord, page 24 may kindly be seen the same page.
Second judgment of the Justice Honorable Judge, fourth time, sorry, again, sir, rejected. That was allowed 2022.
All right, let him reply.
My lord, page 24 may kindly be seen of the
Yes.
impugned order, my lord. Yes. My lord, the 9th line from the top, my lord.
Right.
Knowing fully well.
Right.
Knowing fully well regarding the said fact, PW1 has failed to prove the so-called power of attorney during the course of his evidence. Now, my lord, after that, my lord, filing of petition under 311 of CRPC for re-examination.
How do you know that it's only on terms in only the course of recording evidence these observations are made? How do we know that he has failed to prove already? How can the court already decide whether he's proved or failed to prove? That will come in the final judgment.
My lord, here, thereafter, my lord, the court
is
has
still seized only of the witness action, please. The court is not supposed to conclude whether he has proved or not proved already. The challenge in the present petition under section 482 CRPC is to an order passed by the learned Special Judicial Magistrate Berhampur in 1cc number 80 of 2016 on 6 September 2017. So by the said order, the trial court declined the request of the present petitioner, that is complainant, to recall PW1 to recall PW1 for re-examination. Stop. At the same time, the trial court permitted recall of the same witness for cross-examination by the accused, subject to payment of witness expenses, paragraph. While issuing notice in the present petition on 4th April 2018, the further proceedings in the aforementioned 1C case number 80 of 2016 was stayed by this court. Full stop. That order has continued since. Paragraph. Considering that the trial has already now got delayed by 4 years, the court considers it appropriate to set aside that portion of the impugned order of the trial court dated 6 September 2017, which declines the prayer of the present petitioner for recall of PW1 for the purposes of further examination in chief. Full stop. In any event, the defense would have a further right to further cross-examination of the same witness, which in any event has been allowed to the defense by the same impugned order. Consequently, this court sets aside that portion of the impugned order and permits the recall of PW1 first for further examination in chief by the complainant and then for cross-examination by the defense. The matter will now be listed before the trial court on 13th February 2023. Trial court will now proceed in accordance with law by recalling PW1 in the above terms. Petition is disposed of. A copy of this order be sent to the concerned trial court forthwith. The interim order is vacated.
Item number 84.
What's item 84? My lord, before argument matter, my learned friend is there, opposite part number 2. If a lord she fix up a reopening date, my lord, that.
Why?
Because my lord, here is my lord, I have challenged the cognizance order passed by the learned SDGM.
Under what section?
My lord, the deformation 501 clause B, my lords. Here, my lord, the two present petitioner is my lord, the senior OS officer, and the present opposite party number is the senior IS officer. My lord, the 2016, the WhatsApp SMS, I have received, my lord, the my lord, the very sensitive message, my lord, the highly objectionable, because my lord, the sexual videos, my lord. So thereafter, I lodged an FIR against the persons, my lord, the opposite part number 2, my lords. As per the FIR, police has taken action, my lord, and the person was arrested and the part, my lord, they subsequently, my lord, the charge sheet has already been filed against the present opposite part number 2. Then, my lord, subsequently in the trial, he was acquitted, my lord. After acquittal, I have challenged, my lord, before the session judge, my lord, the session judge, my lord, against the acquittal order. Now, my lord, after acquittal, the opposite party number 2 filed both the defamation case, civil defamation as well as the criminal defamations, my lord. Here is I have challenged, my lord, the criminal defamation issued, my lord, filed by the present opposite party number 2, my lords. Here I have received notice, my lord. I have filed appeal. If you lordship, therefore I pray, my lord, I have some decision I'll cite it. I want to, because yesterday matter was the, my lord, they have, my lord, cited all the decisions, my lord. Keep it, my lord, the reopening any day, my lord. I'll be satisfied for my lord.
No, but that appeal is pending before the district judge.
This is appeal is pending. My appeal is pending, my lord. As the judgment of acquittal, my lords.
All right.
Yes, my lord. Now, my lord, the notice has been, the cognizance has been taken by the learned magistrate against the, my lord, the defamation case has been filed by the present opposite part number 2, and in that case, my lord, the cognizance has been taken by the learned magistrate and issue notice to appear, my lord. So here, my lord, the said, my lord, the defamation is not, my lord, here is the defamation is question that 499 is not applicable, my lords. Here, my lord, the one judgment, I want one judgment, my lord, the Google India Private Limited, but what is the defamation, my lord? That has been, lord, the lordship, I want to, my lord, the one just my lord, the judgment paragraph, my lord.
No, but if it'll all depend on how the appeal is decided, right?
Yes, my lord.
You appear for the complainant.
Yes.
So if the appeal is allowed, what happens? And the acquittal is reversed. It will have an impact. You say the court is informed that the appeal filed by the present petitioner against the acquittal of the respondent by the judgment dated 2nd April 2016 of the Subdivisional Judicial Magistrate Bhubaneswar in CT case number 4696 of 2015 still pending before the learned district judge. Full stop. That view of the matter while continuing the interim order, the court directs the present petition to be placed before the roster bench on 8th May.
Item 85.
Great follow.
Item number 85.
None appears dismissed.
Item number 86.
86, your lordship, I am appearing for the opposite party.
All right, none appears to the petitioner dismissed.
Obliged.
Item number 87.
87, I am for opposite party. All right, none appears to the petitioner dismissed. Thank you. This has been all.
Item number 88.
Then permit the petitioner to raise all the points.
All right. Permitting the petitioner to raise all please at the appropriate stage. All right.
Item number 89.
Item 89, my lords, is arising out of a protest petition converted as a complaint case. Lords, fact remains, my lords.
Where is Mr. Mishra? Mr. Kaliprasan Mishra. Yes.
I am here, my lord. As Sridhar Ratha on behalf of Kaliprasan Mishra, I am on BC, my lord.
Okay.
By some my lords.
Yes.
The fact remains, I am the power of the holder in respect of some plot. The original owner earlier executed another power of attorney, earlier, cancelled it and executed power of attorney in my favor. The earlier power of attorney holder, what he did is, by virtue of that power of attorney, he got the property transferred in the favor of his wife and children. So ultimately, when I was building, I showed a portion of the land without knowing that yes, this has happened. When the dispute arose, there was a compromise. In the compromise, it was decided that all right, you do one thing, we will return you the money. You do cancellation deed, execute the cancellation deed. In the meanwhile, suit, counterclaim, suit bearing number matters, civil suit number 309 of 2018 concerning this property is pending. And we have also filed out counterclaim. This dispute is going on. What the informant did is, he has not gone for cancellation in spite of this agreement. Said, no, you return that money. Then dispute arose. Went to my office, I'm running the medical unit matters. Created a lot of inconvenience. Then we filed an affair, got arrested. Thereafter, remained in custody. The religion of that has come and filed a complaint petition against
cross case.
But alleging that he has gone for a blood pressure checkup, then my persons are assaulted. They think that the police inquiry into the matter. In the inquiry, police submitted the final report that this fact is not true. Thereafter, these conferences.
Suit is pending still. Civil suit is still pending.
Civil suit is pending. The complaint case matters now the purpose petition in the purpose petition.
It is stated that the civil suit instituted by the opposite party.
Yes.
Civil suit
is filed by the original counterclaim.
Right. The owner in respect to the property in question is still in the civil court. Huh? You see, this it is stated that the civil suit filed by the power of attorney holder of the original owner is still in consideration in the civil court. Paragraph. In that way, the matter while continuing the interim order, the court directs the present petition to be listed before the roster bench on 10th May.
I may permitted to make a submission, my lord, in this matter. My lord, I may permitted to make a submission.
Yes.
My lord, the complaint petition of the opposite party number 2 indicates that the allegations made in the complaint petition prima facie make out the offences falling under section 341, 323, 506, 294 and 34 of IPC, besides the offence under 420 of IPC. My lord, the law is well settled that only because of civil dispute and existing between the parties does not exclude the operation of criminal action by one party against the other. Depending on the allegations made in the complaint, prima facie makes out the cognizable offence. In my lord, I have cited 2 Supreme Court decisions. Page number 3, my objection.
You reserve that for the final hearing, sir. You just given a different date. That's all. Yes.
Item number 90.
None of this dismissed.
On para 5, mention all the grounds, para 5. May I read?
Yes, please.
That after the publication of the written test result, the petitioner came to know that he was disqualified. Therefore, in order to check the answer sheet, the petitioner made an application on the RTI Act and obtained the answer sheet. But to his surprise, on verifying the answer sheets, the petitioner came to know that the marks are re-evaluated and his marks are reduced. As a result, the petitioner was disqualified and not called for the interview. And my contention is that there is no procedure actually to re-evaluate. So in the absence of any procedure, the whole process is illegal.
No, but what's wrong with the impugned order? That's what you have to tell us. You're seeking review of an order. What is wrong with that order? You have to tell us.
The Lordship may turn to page 4, my lords, on grounds.
Come to page number 5 and 4th line from the top.
Yes, my lord.
We also verified the answers given. Please
Yes, my
place
lord.
it. Yes.
For that, my lords,
Place it if you want to place.
well, the grounds, sir, I mentioned.
Order under review, sir. Please come to the internal page 5 of the order under review, page 13 of your review petition.
Yes, my lord.
4th line from the top. We also verified the answers given.
But my submission will be,
Yes.
so the court is not an expert, so they
No.
cannot verify.
What are you saying, Mister? You are going to appear in a district judge interview examination. You do not know what is the distinction between theft, extortion, and dacoity.
My lord, I agreed on that.
Your answer sheet.
Yes,
And
yes,
you
yes.
said that yes, he's
Yes,
not.
yes, my lord, I remember. Yes,
no,
remember.
then-
That was a wrong answer. What I am saying is that, my lord, once the marks are evaluated to 50, now it is reduced to less than 50. What I am saying is that there is no procedure at all.
So, any mistake will be committed by the examiner.
Yes, my lord. Yes, my lord.
Examiner will
Yes, the
be
power is
silent.
there.
He has no duty.
Yes, court has a duty to correct it.
Then
I'm not placing that. What I am saying, my lord, there is an impression that even the students after scoring marks, this has been reduced. So as a head of the institution, my prayer would be, my lord, you just take care of all these things. I'm not submitting anything.
No grounds made out for review petitions. All right. Right.
Obligation.
Sir,
Namaskar. Pranam.
Supplementary list, fresh admission item number 1.
Mid-lord. A CMAPL has been filed for restoration of WPC number 8652/2013 disposed of on 14/9/2021, my lord. My sole ground for this, the ground was that the learned counsel was completely bedridden until today also he is completely bedridden. That is why he could not appear on the date fixed, my lord. The counsel has himself also shown the affidavit, my lord.
All right. For the reason stated there, the order dated 14 September 2021 is recalled and writ petition civil 8652 of 2013 is restored to file. The main writ petition sale list before the roster bench on 20th February.
All right.
Item number 2.
My lord, here, my lord, a case was filed against the order of the tribunal. And my lord, 17B was granted. We filed an application, my lord, for recall of that. My lord, they have admitted to the extent that one of the persons, there was a composite affidavit by all, in this case, all the respondents. And that composite affidavit, my lord, they admit that one of them is employed otherwise. They admit that.
No, my lord. There's no admission.
They have to anyway, my lord, my only prayer is that they have to probably file an individual affidavit in each case.
Each of
The
them-
statute provides
Each of
that.
them have filed individual affidavits before your lordship.
Now,
Every one of them has been.
Now, my lord.
Why should we recall then, sir? We need not recall.
Technical objection.
Correct.
And
Now
that-
we need not recall, sir.
my lord, may kindly see, I just want to indicate this, my lord.
Yes.
My lord, may kindly see, open up page number 5, open number 5's petition application, my lord.
Right.
This is that page. Page 4 of his application. The affidavit by OP number 6, my lord.
All right,
My lord, Pradeep Kumar Chotrai.
right,
Now, my lord, independent affidavit has been filed.
yes.
And they admit at page 4.
That since the legal discharge of my services, till date, I'm not gainfully employed.
No, my lord. Page 4,
Yes,
that hence without prejudice, I'm swearing this affidavit. To overcome the technical. Now, my lord, they admit the fact that one of them was employed.
where, who
Yes,
applied?
yes, that is that OP number 5's affidavit.
Huh.
17B, OP number 5.
Hmm.
Page 5, OP number 5's application.
Yes,
That neither during the pendency of the ID case, the petitioner management laid any evidence before the tribunal to say that my alleged gainful employment.
agent of a postal department, that's all right.
Yes, and he
Agent of a postal department.
He is my agent also, my lord. He is my agent also.
It's all right.
My lord, 17B is very clear, my lord. It has gainfully employed, my lord. It stays nothing further.
All right. All right, no, IA number 18845, 2021, having heard learned counsel of the parties and having perused the pleadings in the present application, the court is not inclined to recall the order dated 7th September 2021, the application is dismissed.
Very great. And my lord, may I fix the matter, may any date, my lord, may fix
The
it.
main matter,
Yes, my lord.
you see, the main matter is list before the roster bench for hearing on
Yes,
27th February.
yes, my lord.
Very great.
All right.
Item number 3. Supplementary list item number 3.
None appears dismissed.
OP number 1 by.
Mr. Party for opinion. All right.
Kavita Sav, yes.
Item number 4.
Is he out on?
Still out.
Still out.
Still out, my lord. Till 31st, my lord.
There are 2 orders. Would your lordship have a look at those orders? A coordinate bench of this court. As per the issue. One is in criminal appeal number 214 of 2016. Your lordship may see the paragraph 4. She is continuing on parole. This court considered the prayer for bail despite.
It's all right.
That is not a ratio. That is not a ratio.
All right. It is stated that.
I am reading paragraph 4, my lords. The court says,
yes,
taking into account submissions made going through informed judgment, when it is seen that the case of the prosecution is based on circumstantial evidence, one of the important circumstances sought to be such and such, and it being also stated at the bar that this appellant having been granted furlough for quite some time when during the said period, no such report adverse as to her conduct has come to surface, we are inclined to direct that further execution of sentence imposed upon applicant shall remain suspended and he be released on bail. If this is not the ratio, what is the ratio?
I would like to, my lord,
And then there is, let me complete, Mr. Ragada. In AIR 1980 Supreme Court 785, the word custody has been defined by Honorable Justice Krishna Nair. I continue to be in custody of the court, my lords. So therefore, I am praying, my lords, that instead of adjourning the matter from time to time, waiting for the furlough to end, my lords, I am praying that your lordship may consider my application for bail.
The applicant's furlough is stated to have been extended till 31st January 2023. In that view of the matter, list on 10th February. 10th February.
May I submit, my lords? I am in serious sub item number 4, my lords.
Yes.
That is a criminal appeal number 6 line of 2019.
Right.
I am in custody, my lords.
Yes.
February would be too long a time. I don't press, but it's not today, maybe after vacation in the month.
Doesn't make it. Right, got it.
But keeping it to February, my lord.
Yeah, right. This is another bench. Yes.
Lord, can it be on the 3rd of February?
What difference? 1 week.
Friday, my lord.
No, 10th is also Friday. We kept it for 10th. Right. Pranav.
Namaskar.
Namaskar.
Supplementary list for orders item number 1.
I am so far the criminal appeal number 850 of 2009. I have filed 2 bail applications. One is 594 of 2021 for appellant number 1 and 2. And so far IA number 114121 for the appellant number 3.
Right.
My past submission would be that the principal accused
Yes.
has been already released on bail by virtue of lordship murder.
On 25th November. Yes, sir.
They allowed my
I see.
second
Alright.
submission.
Yes.
He is the principal accused.
Alright.
So far, the present appellants are concerned, only 34 is added, my lord.
Alright.
And there is no materials whatsoever, except that we present in the spot. There is no other materials. I have examined more or less some extent. I have examined the judgment and I have also prepared a note to that extent. Since the principal accused is already released on bail.
All right. Yes, Justice Panigri.
Yes, for the
All right. Correct. IA number 1141 of 2021. This is an application for bail filed by Ganesham Baud, whose appellant number?
3-1.
Appellant number 3. It is seen that he has already been in custody.
Since 4 years, 2 months.
For 4 years and 2 months. Moreover, the principal accused, Ashok Kumar Baut, has already been enlarged on bail by this court in IA number 1225 2021 by an order dated 25th November 2022. Paragraph, it is unlikely that the present appeal will be taken up for hearing in the usual course at an early date. Keeping in view all of the above circumstances, the court directs that during the pendency of the present appeal, the present appellant, Ganesham Baud, shall be released, enlarged on bail, subject to the satisfaction of the trial court.
All right.
The application is
Another 594.
in a different appeal. CRL number 831 by 2019.
That is 830.
So, but another application is 594.
that IA number so and so in criminal appeal 831. All right.
Another IA is 594, so far appellant number 1 and 2 is concerned. Same position, same circumstances.
So IA number 594, same order.
All right.
Same, but the connected appeal is 848 and 849.
Right.
I also stand in the same footing like Mr.
So IA number 592 and 593.
My lord.
All right.
Lordship, another appellant in the same application, CRL 848. Appellant number.
The prisoner's petition, my lord. Initially, I had filed the appeal,
right?
But now the prisoner has engaged Mr. Das.
All right.
Same thing.
Same filed an IA, Lordship.
All right. Okay. All right.
Same order, my lord.
All right. Yes.
848 and 849, other appeals.
Right.
Next.
Namaskar.
Namaste.
Press admission item number 1.
My lord, I am for the petitioner. All the defect has been removed, and this is for the restoration of the appeal. All the defect has been removed, my lord.
All right. Properly bookmarked. The reason stated therein. the order dated 20 July 2022's record, and writ appeal number 111 of 2012 is restored to the file of the roster bench. Then in the writ appeal is see list for the roster bench on 6th March.
Obliged.
Okay, ma'am. Namaste. Namaste.
My very distinguished colleagues, Justice Bhushan Gawai, I fondly call him HMJ every morning. Justice Abhay Oak,